Hi guys, welcome to Nun Academy. Today is the second lecture on CPC. The first lecture I conducted on 19th. That day I told you basic concepts about CPC like cause of action, parties and other things. So today in the second lecture I'll be dealing with jurisdiction. So in the jurisdiction, the basic question from the mains perspective is like today I'll be starting with section 9. Under section 9 there is one concept known as suits of civil nature. So in UP judiciary, the pet question from section 9 is what is the meaning of suit of civil nature. If we will understand what is the suit of civil nature, we will be able to answer the next question which immediately follows this question is, are the following suit of civil nature or not? First one, right to take out religious procession. This is one of the very pet question of PCS-J. Right of Parda Nashi lady to observe Parda. If this right is infringed, will it be coming under suit of civil nature or not? Will it be a civil suit or not? Third, right to franchisee. Fourth, contribution of fund for holding festival. Fifth, right of a priest to worship in a temple. Sixth, expulsion of a member from his caste. All these questions comes in the mains examination to find out whether all these are suits of civil nature or not. So before answering all these questions, we should first of all know what is the meaning of the suit of civil nature. So for this we have to understand section 9. I have written here section 9 is gateway of CPC. Whenever the cause of action arises, the plaintiff will file a suit. So in order to enter into the machinery provided by the CPC, we have to enter through which section? Section 9. Section 9 will show us whether the suit, with which the plaintiff is coming contains an infringement of civil right or not. Whether the suit is ultimately a suit of civil nature or a civil suit. So let us now start with section 9. So for this we have to read section 9 from the Bail Act. Section 9 reads as courts to try all civil suits unless barred. The court shall, subject to the provision herein contained, have jurisdiction to try all suits of a civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. You should read this provision for 3 or 4 times before continuing with my lecture. I am removing this. I hope you have already written this. This is the mains question which comes from section 9. As I told you that section 9 is the gateway of CPC, you can also, it is like a Khulja Simsim. Khulja Simsim of the machinery provided by the CPC. What is machinery? What is machinery does? It provides us us with the procedure, how to get justice, how to get one's right enforced, how to make one be liable for anything. So section 9 is the gateway of CPC. For this, when we read section 9, the court shall have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. The very first word we got is what? Jurisdiction. What is jurisdiction? For section 9, first word is jurisdiction. What is jurisdiction? Jurisdiction is the power to try a suit, is the authority to listen to the facts, is the authority to pronounce a judgment, is the authority to execute a decree. From the very starting till the end, for each and every incidental proceeding, the court should have the jurisdiction. So, in a very general sense, the meaning of jurisdiction is power, authority, competency of any court to deal with any case. And the very important case law for jurisdiction is Sachindranath Chatterjee official trustee versus Sachindranath Chatterjee 1969. Here in this case, what the court said? Court said that jurisdiction gives the court the right of administering justice by means of law. Means by means of law providing justice to the people. This is what jurisdiction means. Thus, jurisdiction means the power or authority of a court to inquire into the facts, to apply the law and to pronounce a judgment and to carry it into execution. This was held in the case of Ujjain Bai versus state of Uttar Pradesh. Ujjain Bai versus state of Uttar Pradesh. In the law schools, in our colleges, we must have heard two words. One is lack of jurisdiction, one is irregular exercise of jurisdiction. But before getting into this, I must tell you one more thing. Quorum non judice. I am just telling you very not going into deep, because jurisdiction I will be dealing again in my next videos. Before getting into place of suing and other things, I'll tell you different kinds of jurisdiction and all that. This is just a simple gist of jurisdiction today I'm telling you, because the introduction is jurisdiction. So Ujjain Bai in this state, it was held. What was held? I told you. One is this quorum non judice. Quorum non judice. One word. Quorum non judice. It means not before the judge. Not before a judge. Quorum non judice means not before a judge. When a decree is passed by a court without jurisdiction, it is a quorum non judice decree. That a decree not given by a judge. Okay? Now, irregular exercise of jurisdiction and lack of jurisdiction. Irregular exercise of jurisdiction and lack of jurisdiction. They both are not synonymous. Like existence of jurisdiction and exercise of jurisdiction are not synonymous. In the same way, lack of jurisdiction and irregular exercise of jurisdiction are not synonymous. I'll tell you without writing. See, in the when a jurisdiction exists, then the court exercises the jurisdiction. But in some cases, there is no jurisdiction, still the court exercises the jurisdiction. When a court exercises the jurisdiction, seeing that it has jurisdiction, but incidentally it deals with other issues also, and in doing so, it commits an error, then in such a situation, there is an irregular exercise of jurisdiction. And this is curable too. While in the case of lack of jurisdiction, the court from the very inception doesn't have jurisdiction. And this is not curable. It cannot be validated. So, next thing, one more important thing in the lack of jurisdiction is that an order of court lacking jurisdiction has to be respected till it is set aside by a competent court. These two things, concepts, lack of jurisdiction and irregular exercise of jurisdiction, are very important. Okay? Now, this was about jurisdiction. Now the second point is, again we'll read section 9. The court shall have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. To try what? To try all suits of civil nature. Now it comes suits of civil nature. What is this suit of civil nature? See, section 9 is saying that very general principle is that all the courts have the jurisdiction to try a suit. Okay? And the very exception of this general principle is the expressly barred courts from exercising the jurisdiction and impliedly barred. Therefore, with the general principle from section 9 which emerge is court can try all suits which involve determination of any civil right. Court can try all suits which involve determination of any civil right. So, for this, two things are very important. First, the suit must be of a civil nature. Second, the suit must not be expressly or impliedly barred. Now we will come to the point of what is suit of civil nature. See, suit are basically of two nature. One civil nature, one not civil nature. This is further divided. Civil nature suit is further divided. We'll deal it afterwards. See, what is a suit of civil nature has been further given in explanation 1 of section 9. Let's read. A suit in which the right to property or to an office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on the decision of question as to religious rites or ceremonies. Read it again. A suit in which the right to property or to an office is contested is a suit of civil nature, notwithstanding that such right may depend entirely on the decision of the question as to religious rites or ceremonies. So what comes from explanation 1? What clarification is being given by section 1? See, the clarification is first point. If the principal or the only question in the suit is a question relating to caste, is a question relating to religious rites or ceremonies, then the suit does not deal with the right of the citizen, but with matters which are either social or religious and is not a suit of civil nature. First point. Second, if the question relating to a caste or religious rites or ceremonies is not the principal question in the suit but only a subsidiary or an incidental one. So what's the primary one here? If the principal question is one relating to a right to property or office or any other civil right. Third point, such a question cannot be decided without determining the question relating to the caste or religious rites or ceremonies. The court can decide the question as to the caste, religious rites or ceremonies to enable it to adjudicate the principal question. The principal question being the question relating to a right to property or to an office or to any other civil right. Therefore, what comes is a suit is of a civil nature if the principal question therein relates to a civil right. So, civil nature. Suit of civil nature means if the principal question relates to a civil right, it is a suit of civil nature. Regardless of the fact that in adjudication of the civil right, the court has to adjudicate on the religious rites and ceremonies also. This is what explanation 1 is telling. Okay? Words such as suit of civil nature as used in section 9 gives an expansive meaning and application to the jurisdiction of the court. It is not only a pure civil suit that the court will have jurisdiction. It is not only a pure civil suit that the court will have jurisdiction. Rather, the jurisdiction will be also upon suits which involves socio-religious questions. The only condition being the principal question should relate to property or the office. See, explanation 1 is not exhaustive. The right to property or the right to office are only examples, are only illustrations of suit of civil nature. There can be many other things which include suit of civil nature. So, it's not that right to property, right to office, including where the subsidiary question being on religious rights or something is a suit of civil nature. No, explanation 1 is not exhaustive. Okay. Therefore, what is suit of civil nature? Suit of civil nature is civil nature suit of two nature, civil nature and not civil nature. Now suit of civil nature is further divided into pure civil suit, involving socio-religious issues. Okay, pure civil suit involving socio-religious issues. These are two types of suit of civil nature. Okay. In the pure civil suit, there is no social religious issues, but in other kind of suit of civil nature, there is socio religious issues too. For example, A had any legal right. Okay. This got violated. This is a pure civil suit. But if the non-existence of this legal right depends on what? On socio-religious issues. Then we have to deal with the social-religious issues also. But the primary question is of legal right. Therefore, it is what? It is a suit of civil nature. So, now I will tell you the formula which I have derived from these observations. The formula is that suit of civil nature is equal to civil suit plus socio-religious rights or ceremonies. In terms of right to property, right to office examples. Okay, this is what I have reached on. Suit of civil nature is equal to civil suit, where the, see, if we hide this suit of civil nature, civil suit, okay. If there is some socio-religious rights or something, then also this in this civil suit should be the primary question. This legal right in this civil suit should be the primary question. Okay. Now when the case comes, what's the approach under section 9? First one, this is the approach. Whether the suit is of civil nature, means pure legal right and infringement of legal right. Second, whether the suit is whether the suit is civil suit, this is the pure nature, whether the suit is suit of civil nature, third, whether the suit is religious, purely social or religious. Okay, this is the point. The court won't have any jurisdiction. In these two, the court will have jurisdiction. Okay, the 3 points which I told you in explanation 1 are very important. Okay, so you must write down that in your mains exams. So a suit of civil nature is a suit in which essentially the violation of a legal right is involved, though there may be some associated socio-religious rights also involved. The real test to examine whether a suit is of civil nature or not is to examine the cause of action of a suit. And if it is found that the cause of action is essentially the existence of a civil legal right and violation of such right, and it will be a suit of the real test to examine whether a suit is of civil nature or not is to examine the cause of action of the suit, and if it is found that the cause of action arises from a legal right being infringed, plus that legal right is dependent upon some socio-religious rites or ceremonies or any other issue of such social or religious issues, then also the suit will be a kind of civil suit, means a kind of suit of civil nature. Okay? Unless and until we will be able to understand or recognize suits of civil nature, we won't be able to answer those 5 or 6 points of question which I told you, whether right to take out religious possession, where a member is expelled from a caste, and all these things. Okay? So we'll take some social religious questions now. Okay? First one, the caste questions. What if a member, one person is expelled from his caste? No one is talking to him. Now he's filed a suit against the villagers to reinstate him in the caste. Okay, will this be a civil suit? Where a person is expelled from his caste, no one is talking to him, now he is filing a suit to get reinstated in the caste back again. Will it amount to a civil suit? A suit of civil nature? No. Why? Because the only infringement here is, in this example, is the right to be a member of the caste. Is it recognizable as a right by any law? No. Therefore, this is not a legal right. Okay? If it's not a legal right, it is getting infringed of whatever is happening. CPC is not bordered for this. Okay? So, here no cause of action arose. Now there is birth of any civil suit. So, this is not a civil suit according to section 9. Okay? What is caste? Caste is any well-defined community. Okay? Caste is governed by its own rules and regulations. It has its own autonomy, independentness. It has its own social relations. That's why law doesn't interfere in all these things. Because of their social autonomy. Okay? Internal autonomy, social relations. Now, if because of this expulsion, the person is suffering, he has He has no shelter, no food, water. Constitution provides us the right, the fundamental right, food, water, everything. If this is violated, then it is a violation of legal right. Hence, in this case, where such rights are violated, it is a suit of civil nature. Irrespective of the fact that in determining whether his right is infringed or not, we have to go deep. Whether his expulsion from the caste was right or wrong. Okay. The primary question here, now also, what? Right to food, shelter and that thing. Secondary question is about that social religious caste questions. This is what the suit of civil nature is. Irrespective of the fact that a social religious issue is involved, but the primary question being the infringement of a legal right, civil legal right, still it is a suit of civil nature. The court has jurisdiction to take cognizance of such cases. Okay? Here I should tell you that the real test to examine, I am again telling you, to examine whether a suit of civil nature exists or not is to examine the cause of action of a suit. And if it is found that the cause of action of suit is essentially the existence of a civil legal right and violation of such right, it will be a suit of civil nature, even though some matter in issue are of socio-religious nature and the determination of the civil right and its violation would depend upon such socio-religious matter in issue. Okay? Then now an additional, I am going more deep into this caste question. On the very face of it, a suit by a member of caste who is expelled is not a civil suit, because being member of a caste is not a legal right. Okay? Now getting deep more, expulsion from caste. Till now I have told you from jurisdiction, whenever a question will come, explain section 9. First of all, you will write in your own words or the provision given section about section 9, the first 2 lines. Then you will start with the jurisdiction. Whatever I told you, write that jurisdiction part. Then you will start with suit of civil nature. Whatever I told you, write the civil nature along with the explanation 1. Write these 3 points. Write the real test for determining a civil suit of civil nature. Okay? You can add the social religious question like caste question. Now the next thing is expulsion from caste. I'll teach you in the next class. In the next video I'll continue this was the second lecture. I'll continue it in the second further videos. Okay, please subscribe to my channel and like my video, and if you have any problem, please comment me. I'll surely answer your question.